everyone, and welcome back to the CLSR. And I'm your host, the counselor. Just want to let you people know you can get a hold of me at TheCounselor@gmail.com. That's the counselor at gmail.com. Now, I want to say to all my wonderful listeners out there, let's continue to spread the word like the wise old bird and put your money where your mouth is so we can handle this biz. Take care. Welcome back to the CLSR, and I'm your host, the counselor. And today we're going to talk about the George Floyd case. We're going to do a little bit of reflection on this case. And I have to say, like millions of people right now, I'm focused in, and it's just heartbreaking. I mean, scene after scene, testimonials, these eyewitnesses, just how things are unfolded. And really what's damning is the videotape. Just watching this, like, your heart has to break, and you could sit there and go, no matter what the defense is, no matter what psychological decision George Floyd was contemplating, there's no explanation or no excuse why someone would be sitting on someone's neck. First and foremost, there's just that. First of all, how do you even argue that? Why is this even a court case? Like, even if it was whatever, one of the most heinous, should you still be on someone's neck? And why are you on someone's neck? Not on their shoulder, not on their chest, not holding them down by their legs, not even pushing their face to the ground or shoving them into the car. The neck, you are on a person's neck, and you are supposed to be a protector for the people, and you are on the people's neck, and someone dies because of it. How do you look yourself in the mirror, and how does the agency do such a thing? Like, the neck, you are taking somebody's life, you are on their neck. No excuses, no amount of evidence, and no judgment. It's clear. You see, the really scary part is that more than ever in history, we have access to communications, immediate access, via cell phones, cameras. Everything is at our disposal when it comes to analyzing scenes. And I gotta say, people say, oh, you know what? No two people say the same thing. That's garbage. We all see what we see. And when we see it on the video, when we see people coming out of the store, we see George Floyd's beside the car, and all this time, somebody's on it, and these people are helpless watching because they're being threatened. Stay back, stay back. And the officers are doing what they're doing. But all this time, people are just in shock and awe. And you can't possibly fathom being one of those people standing on that corner watching this unfold. Like, their hearts and their minds must be boggled with frustration and grief and guilt. I mean, there's not enough tears that could just explain how you would feel watching somebody right in front of your eyes go down. And then when you hear some of the testimony of the EMS workers and saying how by the time they got to that scene, it appeared like it was just too late. And there are many different sides to this thing, but I mean, there's a lot of evidence. And despite this evidence, it is clear what has happened. A plus B equals C. The antecedent, what led up to this, is clear. The behavior is clear. But the cause is super clear. And that should not be there. You're not there for that. You're not there for that. You're there to protect. There was no immediate threat. The man was showing you he was cooperating. Despite his mental, psychological good, he was in handcuffs. And see, if it doesn't get any deeper than that, I don't know what to tell you. I don't know what else we can do. I think we're sitting here in 2021 with all the means and all the access, but we lack the action. I can understand why people are out of their minds with frustration. I know I am. It doesn't matter what type of book I'm reading. It doesn't make sense that this is going down. There's no explaining it away. And see, this is the thing too. When you have lawyers and just listening to some of the questions that are being asked and just seeing how displaced some of this information is. And you see a lot of us, we don't know what direction they're going at. Like, what are they getting at with some of these questions? Maybe the family members had a drug issue. Maybe they passed off a fake dollar bill. Maybe they had problems in the family. Maybe there were health concerns. Maybe, no, that's not enough. Because what is really going down is people are ignoring what they see. And they are saying to themselves, well, it isn't what it is. So we have to go through this process. Well, I think today what I'm going to do is I'm going to talk about some court terms and how people get evidence thrown out. I'm not suggesting anybody get evidence thrown out, but a lot of the times my concern is that the evidence is clear here. You can see it, I could see it, and there's no lying. The evidence is clear. And for this evidence that's being presented even by the defense, you have to say to yourself, the defense is presenting some questions here, and a lot of the viewers don't know what direction these questions are leading to. And if I think I'm sitting at home, I'm a layman, right? The average person. And if I'm sitting at home and I'm saying to myself, how could this go wrong? There's just no way there could be a not guilty verdict. Or either way, there's just no way because it seems like it's so evident. Well, the truth is there are ways when something, and this is what the black community has been dealing with for so long, far too long, is when the evidence is clear, somehow it either gets thrown out, dismissed, or denied. And the reason why that happens is because we don't, as lay people, understand how that happens when it could be so clear. And that's why the counselor is going to talk to you today. Because I need to let you know how evidence gets thrown out, and something that you could see clear as day, right, could get thrown out. And you're like, well, there's so many possibilities here, but can you break it down, counselor? Well, the counselor's going to break it down. And he's going to let you right now, give you a basic understanding of some of the terms on how something, even as this George Floyd court case gets thrown out. And you do need to listen, and you do need to have a sit down with your family members to get an understanding. Because as much as the commentators on those news programs want to talk to you and do their momentary commentation, I'm going to break it down. I'm going to transfer my knowledge from what I've learned from professionals out there just doing the reading, and how people don't understand how this evidence could get thrown out and dismissed and discharged or whatever. How does this happen? Well, we're going to talk about that, because in actuality, there are several ways that this happens. There's several ways to get evidence thrown out of court. Evidence is any type of proof legally presented at trial which is offered in order to convince the judge or jury of alleged material facts in the case. Evidence includes oral testimony of witnesses, documents, public records, and objects. A good lawyer will help you identify testimony that can be challenged and excluded from trial. Generally, evidence can be excluded when it is unreliable, prejudicial, not authentic, or where its admission would violate a public policy. Now, you might think of excluding evidence as unreliable. See, challenge a witness's competency. And that's what's happening right now, as you see, with the George Floyd case. So you see, they got his family members up there, well, his girlfriend up there, and some witnesses. So what they're going to do is these people made statements, okay, when this incident happened, okay, a while back. And they made these statements based on their account of what was going on. And so now the job is to challenge a witness's competency. And you can see how this is being challenged. A witness is only competent to testify about an event if he or she has personal knowledge of it. Object to any witness who begins testifying about an event without first establishing that he or she has observed it. And see, this is where they try to discredit them by saying, did you see what you told us that you saw a year ago? And so if they can show any discrepancy from what you said before to what you're saying now, then it starts to weaken things. See, as the witness is testifying, you or your lawyer stands up and says, objection, Your Honor, and then states your grounds. Here, the grounds are lack of personal knowledge. So if you want to say these things and be challenged, you know what I mean, then you have to understand that, it could go both ways. The defense could do it, right? Or the prosecutors can do it. They could object to what you say you saw and discredit you, right? That's called challenging a witness, all right? As well, identify lay opinion testimony. A lay witness may only testify to what he or she observed. They are not allowed to provide expert testimony, but can only offer opinion that is rationally based on their perception, how they saw things. Acceptable lay opinion includes opinion about size, sound, weight, distance, or manner of conduct. Like, I thought she was tall is acceptable lay opinion testimony. The lay witness, however, cannot purport to give scientific opinion. I thought she was criminally insane is unacceptable lay opinion testimony. You should move to strike testimony of that nature. So if one of those witnesses start talking about scientific opinion and how it relates to a crazy person, well, that's not acceptable, and that could be thrown out. So these are terms that you have to be mindful of, right? Because they're considered not reliable. Now move to strike hearsay evidence. What is that? Hearsay is a term for testimony in court from a witness who does not have personal knowledge of the events that they are testifying to. Instead, they were told the information by someone else, right? Because a witness must have personal knowledge of an event he or she testifies to, you can often get hearsay evidence thrown out. So let's say if they weren't the ones reporting, but they said they made statements, but they weren't the ones who actually saw it, they get discredited. See, a classic example of hearsay would be if someone testified that they heard something somebody had done but didn't see it themselves. There are several exceptions to the hearsay rule. Among the more common are an excited utterance, a statement made for purposes of obtaining medical treatment, like a dying declaration, and statements against interest. These hearsay statements are allowed because they have circumstantial guarantees of trustworthiness. So if somebody on their deathbed says, they told me on their deathbed that, somebody was trying to kill them, they actually consider this type of hearsay, even though it was from a third person. You understand? And you know why. I just told you why, right? That's what you got to think about. You understand? What do they take and accept? All right? You know what I mean? What do they accept in the court? See, this type of statement, this hearsay, the dying declaration, is something else that needs to be considered. And they actually start looking at it. But if you heard it from a third person, like a buddy of yours, and then you're going to make that statement, they don't want to hear that at all. See, if the declarant is unavailable, the person who made the initial claim, then his out of court statements may be admitted through hearsay if they're unavailable. See, that's another thing. Let's say if your friend testified that you did something, all right, but then y'all know about this, but then all of a sudden they're supposed to show up for court, but then they don't show up for court. Do you understand? Or they're unavailable. And let's say they changed their mind, and you're the lawyer that, you question them, and they made statements initially, and then the prosecutors ran with it. But then they changed their mind, and you're the defense, and you want to go bring them to court. Well, the thing about it is, if you don't get them to court, then the court might accept that initial statement. All right? So keep that in mind. All right. If the statement was given during another trial or proceeding under oath, and if the statement was subject to cross-examination at that time, then it may be admitted into evidence. Additionally, any statement made by a party is admissible against that party. For example, if you admitted to your neighbor that you were responsible for hitting the plaintiff with your car, then your neighbor can repeat your statement in court. Think about that. Now, when it comes to argue the evidence was coerced, do you understand that? The due process clause prevents the government from introducing any statement that was made involuntarily. You can get a confession thrown out if it was made involuntarily. What does that mean? And you've seen 48 Hours, all them shows where they're in there and you're just like saying to yourself on bated breath, you're just like, yo, fool, you did it. Why don't you just say to them, I plead the fifth, and get it over with? But the truth is, there's a lot of discrepancy there, okay? Because the person ends up talking on and they end up burying themselves, all right? You know what I mean? So they end up talking, blah, blah, blah. They scared, whatever. And then they end up saying the truth, the whole story, whatever. Not all in all cases, but they end up saying what they did. They were in there and they were tired. And you know what? They were there for 5-10 hours. You know what I mean? And they said everything. So everybody got them. You're charged. You're going to jail for the rest of your life, etc., etc. But the truth is, if they can prove that this person was under duress, you know what I mean? And they were in there for too long, like 6-7 hours. It was actually not voluntary. It was involuntary. And then if they could see that somebody was, sending them questions, you know what I mean? Making assertions, and that person might reiterate them, say them back. And next thing you know, there's just some discrepancy there. See, right there, you could argue that the evidence was coerced or basically influenced by the questioner. All right. Among the factors a court will consider are threats, promises, physical coercion, like if you're being threatened physically, the length of the interrogation, as well as the defendant's health, age, and intelligence. The ultimate standard is when the defendant's free will was overborne by police coercion. You know what I'm saying? So basically, think about that. Right? When you're coerced or influenced. So I told you, it's all of these things. So think about somebody who's maybe, who has a mental deficiency and they're being questioned. That could be considered by the court as coerced. Or if they're an old person, they don't really understand that well. You understand? If the person's intelligence, you know what I mean? If they're not a very intelligent person, then that could be a factor as well. Or if they're being threatened. And I told you about the time. If they're told, you know what I mean? Oh, you know what? We promise if you tell us the truth, we're going to get you. You're not going to do 25 years. You're only going to do 10 years. So let us know the truth right now. We promise we're going to give you only 10 years as opposed to life in prison. See, that's a promise that's being made. Or a threat. If you don't tell, if you don't tell the truth, what we're going to do is put you in jail for the rest of your life. You know what I mean? Or if they end up touching you or picking you up, let's say you're in the interrogation room and you're sitting there and they want to, scare you or something. So what they do is they bring in these big investigators and, they intimidate you. But if they physically, like, let's say if they do, pick up a chair or something, they don't hit you with it. But if they pick up a chair and they threaten, and then you're feeling threatened, all these things could go back to the courts and the judge could look at them and say, wait a minute, there's too much coercion here. And that means it could be thrown out. Now, the reason why I'm telling you this and the counselor's discussing this is because we have rights. But we also have to remember it's not just for the defendant, right? It's also for the prosecutor, right? If the prosecutors got somebody dead to rights and then they say, look, no, we see what happened there. That person came up here and testified, but they were influenced by the defense. They were coached by him. See, that's another thing that could be argued, that they were coerced. They were coached by the defense. So half the statement that they made was not really there. So if that could be proved, it could be thrown out. Do you understand? So why would that work on a defense case? So let's say somebody's been in jail for years and then they're trying to get out. And then they want, their last hope is the appeal. And their appeal is, well, we're going to, the statement was coerced, etc. They were feeling threatened and da-da-da-da-da. Well, the prosecutor can use those same arguments to keep the person in there, right? They could say, well, they were promised, Your Honor, this, or, you know what I mean? There was some sort of interrogation where, right now, it's changed. The age of the person has changed. So, it hasn't been that long since this has happened, and much of the things are still the same. So it could be used either way. You know what I mean? It could be argued either way when you think about it. You also have to think about throwing out prejudicial evidence. Move to exclude character evidence. You can throw out evidence of a character trait if it is offered to prove that you acted in accordance with the trait on a particular occasion. See, courts see this evidence as inherently prejudicial and irrelevant. See, the purpose behind this rule is to focus the jury's attention on the main issue. What happened on this particular occasion, and to prevent the jury from rewarding good people and punishing bad people based on their character. There are exceptions. For example, if in a criminal trial a defendant offers evidence that he is generally peaceful, then the government could offer evidence to refute it, to go against it. A defendant in a criminal trial may also offer evidence of a victim's character trait, such as a violent character, which the government may also rebuke. Do you understand? So the character evidence does not match up with the person. You know what I'm saying? So they could be challenged. That's how you could get it thrown out. It could be challenged. There are examples that we can discuss. Okay, so let's think of this. Let's think of a juror, right? So let's say a jurors, there's like 12 of them or whatever, and they have to make a decision. So let's say that one of the jurors is picked, and the person who's on trial was on trial for assaulting. And then they get this presented information about how they behaved probably 10 years ago. Maybe they assaulted somebody, you know what I mean? And it was similar to what was happening. Well, that could be thrown out and argued if the person's trying to attribute that to them. So let's say 10 years ago they were aggressive and mean, but then recently they've straightened out. They go to church. They don't act a fool. They don't do anything. So then if the jurors have been instructed to reflect back to the bad negative 10 years ago, that may be argued that it's not congruent. The judge doesn't want them to be perceived as good or bad, so they want them to deal with what's happening now, not on the past. But if they see that evidence slipped into the case, all right, then that means that that's given a painted picture of the person, which is prejudicial. Meaningly, it's prejudging the person based on their previous behavior years ago, not what's happened recently. Or, you know what I mean? Something that they did, or an incident. Might not even been that long ago, but it might have been a minor incident. But now you're taking that minor incident and applying it to what's happening now, when that might not be the case. So they want to eliminate all prejudgments. But if it comes in and it's admitted, right, and one of the prosecutors or the defense, they don't see it, but it gets admitted in there from a case, and then the judge looks at it and he might say, you know what, we gotta, this, you can dismiss that because it shouldn't have been brought in. And now the jurors have been prejudiced, so now they can't think of nothing but what you did when you were 16 years old, as opposed to you being 30. Well, you know what? We got 3 parts to this. We got to talk about the George Floyd case, but we're going to talk about some terms, and I love talking about it. But I need you to listen, because you're going to have part 2. We're going to go through the motions, and we're going to get some of these terms down. So when you're watching, you're an informed audience. And that's what the counselor is going to do. He's going to make you an informed audience member just by discussing some of these terms. All right? So take care, people, and I want you to be like the wise old bird and spread the word. And go to allmylinks.com, the CLSR. All right? So it's allmylinks.com / the CLSR. And I want you to go check out my podcast, buy some gear. And we're going to put some new gear up there. Okay? We're going to show our support. And I want my listeners to spread the word and wait for my t-shirts, because I think we need to show our support for what's going on. All right? And we need to bring resources together so we can educate people. We want to make sure that this man did not die in vain. We want to educate the public. Do you understand? If anything, when these things are happening, we need to up our game and start changing the curriculum and start changing some of the policies and procedures in our workplace that show this, where people see things and they don't act on it and they try to give all kinds of excuses for it. We got work to do, people. Let's keep that clear. All right, so this is the counsel over. Now wait for part 2, the George Floyd trial. We're going to do some talking. Take care.